You're watching Capital City Sunday.
Good morning. This week on Capital City Sunday, new movement in a lawsuit that questions how government functions in Wisconsin.
Legislatures aren't equipped to know in advance every single possible spending project that will come up. And that's actually an argument in favor of some kind of legislative veto.
Political reporter Darielle Fair sits down with a political science expert after attorneys for Governor Tony Evers and legislative Republicans go before the Wisconsin Supreme Court in a case that deals with how much power legislative committees should have.
Stop playing political games and get this needed money to the people in the communities that need it.
And after Republicans on the Finance Committee ignore a call from Governor Evers to release funding to fight PFAS, we're hearing from people in the areas that say they need help now.
Biden administration is caught between these multiple competing goals in the conflict.
And conflict in the Middle East, the concerns over a widening war and how those tensions overseas affect us here at home. Thanks for joining us. I'm Sarah Massler-Donar. The Wisconsin Supreme Court heard oral arguments this week in a case dealing with the powers of legislative committees. Governor Tony Evers filed the lawsuit in October after Republicans on the Joint Finance Committee withheld pay raises for Universities of Wisconsin employees. It has also blocked certain conservation projects. Evers argues the committee is exceeding its constitutional lawmaking authority. The legislature countered that its powers are well established in state law and precedent. During the hearing this week, justices questioned just how much power committees should have.
Question for you is, would Governor Evers welcome a restoration of the original understanding of the separation of powers in the state of Wisconsin and welcome the repeal of executive agencies making law?
Or how about the legislature just pass laws and let the executive execute them? This is how government has worked since the beginning of time.
Political reporter Darielle Fair talked with a political science expert who breaks down what is set out in state law and how this case could affect state government as we know it.
A major argument of this case focuses on the program created by the legislature that gives the Department of Natural Resources the authority to administer and request funds for conservation projects. Joining me now is UW-Madison Professor of Political Science, Howard Schweber. Howard, thank you so much for joining us.
Oh, thank you for having me.
Now, the DNR can request approval for those funds through the Joint Finance Committee, and then Governor Evers signs off on them. How did the way the process is done lead to this lawsuit?
The legislature allocated millions of dollars that can be spent by DNR on reclamation projects, grants to local governments and nonprofits, and related projects. What they also added, though, was that the Joint Finance Committee can veto a specific expenditure. This is what's called a legislative veto. It's where, so when we were all in high school or watching Schoolhouse Rock, we all learned that the legislature passes a bill and makes a law and allocates money, and then the executive spends that money. This is a system that adds one more step, which is that the legislature can veto a specific spending allocation decision by the executive, and that's the part that's controversial.
And to your point, Professor Schweber, in regards to that veto power, during oral arguments, some of the liberal-leaning justices, Justice Jill Karofsky and Justice Janet Protasewicz, questioned how the Joint Finance Committee functions and what authority it has to determine how money is spent in the state. The committee has vetoed other funding proposals like pay raises for UW employees, and it has not released funding to fight PFAS and address the Chippewa Valley healthcare crisis. Is the committee abusing this veto power?
Well, the veto power in Wisconsin is, constitutionally speaking, a monstrosity. A little background. At the federal level, the U.S. Supreme Court ruled way back in 1983 that this kind of legislative veto violates separation of powers. Since that time, 20 different state courts, more than 20 state Supreme Courts have reviewed the question, and every single one of them, with one exception, has found that legislative vetoes are unconstitutional. The one exception from Idaho involved a very different system in which the whole legislature had to vote to veto something. Wisconsin's program allows the Joint Finance Committee, by a vote of 5 members, representing 5% of the population, to veto any expenditure, and any one member of the committee can veto any expenditure over $250,000 and can do so anonymously. So without giving any reasons, without any kind of accountability, without any claim at all of democratic representation, a single member of the Finance Committee holds veto power over the entire operation of state government in this area. No court that has considered this question has ever upheld anything remotely like that as being constitutional. So the problem, and people have to understand, is that Wisconsin's system in place is really extreme to the point of, I'm not sure how to say this strongly enough, the most extreme of which I'm aware anywhere in the country. And that's why it is so controversial. There are good arguments for allowing, for example, what Idaho allows. I just mentioned that. Certain forms of legislative veto where the whole legislature acting as collectively vetoes a spending decision. But it's an absolute flouting of any conception of separation of powers that a single member or even a single committee overrule the executive after funds have been granted by the legislature.
And during oral arguments, Justice Karofsky said, quote, "State government as we know it is going to change drastically if they move forward with a decision on this. What are the greater implications of this lawsuit?"
I don't know that that's true. What people are always saying that in the famous federal case back in the 80s, that was the claim. But what it would mean is one of two things. Either the legislature would have to, in order to, if the legislature doesn't want money spent on certain things, it will have to be much more specific in drafting its spending bills. And that's really a problem. Legislatures aren't really equipped for that. Legislatures aren't equipped to know in advance every single possible spending project that will come up. And that's actually the argument in favor of some kind of legislative veto. That is, there should be arguably something as a pragmatic matter, something in between a blank check, spend this money however you want, and constant intermeddling in a way that violates separation of powers. So I would hope, my own hope is that the state Supreme Court will reach a decision that going forward permits some version of a legislative veto, just not the rather outrageous version that Wisconsin has at present. The other possibility, of course, is simply that the legislature will stop being able to veto independent and specific spending decisions, and I have to say I have a hard time seeing that as a drastic change in the manner in which state government operates.
And I want to show an exchange between Chief Justice-elect Ziegler and one of the attorneys right now.
So why shouldn't our court hold this decision in abeyance until we can hear out all these other issues to make sure we are consistent with the way we're deciding these things? So we are sure we aren't missing something when it comes to treating all three branches the same with respect to their power and authority.
There we see Justice Ziegler asking counsel, what's the rush? Both sides have said they were not able to fully develop the facts in their arguments. Is there a need for the court to rule on this case sooner rather than later?
Maybe, maybe not, but more to the point, I think, is there's no real need for delay. So the reason to delay hearing a case like this is to allow the facts to be developed, the facts of the particular spending programs, the particular procedures, what's happened. This really presents a pretty much a pure constitutional law question. Is a legislative veto in which a veto is possible by a single member, or a legislative veto in which a veto is possible by a committee, constitutionally acceptable? As I say, more than 20 state courts and the U.S. Supreme Court have all said no, that is not acceptable as a matter of constitutional law. So the Wisconsin court would be a very extreme outlier if it were to allow this procedure to continue regardless of the facts of this particular case. So on the one hand, ordinarily, the Supreme Court should refrain from taking up cases until all the facts are developed, if the facts are in any way relevant to legal questions before it. But this case really presents, sort of a textbook or a con law class exam kind of standard question of constitutional principle that can be answered purely in the abstract. And I have to say, I don't see what further development of the specific facts has to do with the ruling in the case. Obviously, those facts affect how we feel as a policy matter about particular decisions. For example, Republicans in the legislature objected to a spending program that did not have sufficient buy-in from local government, and some of them said they might approve it with different terms. So the policy questions on particular spending choices, very much can be fact-dependent and detail-dependent, but the separation of powers question is really one that exists in the abstract and has to be answered consistently, as Justice Ziegler said, for all cases, based on the Wisconsin Constitution, without attention to what specific facts are at stake in one particular controversy or another.
Thank you so much for joining us today, Professor Schweber.
My pleasure.
Last week, legislative Republicans filed another lawsuit challenging the governor's partial veto powers. This time they allege he improperly struck sections of a bill that set up a plan to spend $50 million on student literacy. A spokesperson for Evers said in a statement that Republicans didn't seem to have any problem with partial vetoes until a Democrat took office. Right now, 2 Wisconsin groups are suing to let voters with disabilities vote electronically. The lawsuit from Disability Rights Wisconsin and the League of Women Voters of Wisconsin says not letting people with disabilities vote electronically in the upcoming elections is unconstitutional. The groups argue many voters with disabilities need help to fill out a paper ballot, and that goes against the state constitution, which says all votes will be a secret ballot. The state allows military and overseas voters to use electronic absentee voting. Coming up, the trickle-down effect, how a deadlock over what to do with funding allocated to fight PFAS in Wisconsin's drinking water is impacting people whose water is unsafe now.